once again. Do you want to look?
Ma'am. In brief, yeah.
Brief? Okay, so we were looking at section 9 of the Singapore law, which said that there can be a disclosure to a third party with the consent of all the parties, or if it is made by a person who is not a party but who is there as a participant. That is, if a person has joined the mediation, let us say as an advisor, or if the mediation is being administered by an institution, and I think one of you is a conciliator with an ODR institution. So you know that when an ODR institution does conciliation or mediation, you have case managers, you have people from the institution who may participate in the mediation. So such persons are not parties. That is, they are not concerned with the dispute, but they are part of the mediation in a different capacity. So if the communication is made by this other participant, then with the consent of that participant, you can have that shared. It also says that it can be made if the disclosure can be made or confidentiality will not be applicable if the information is already known to the public. It's in the public domain already. It says you can share the information if the disclosure is necessary to prevent or minimize the danger of injury to any person, or the abuse, neglect, abandonment, or exploitation of any children or young people. If the disclosure is made for research or educational purposes. If the disclosure is made for seeking legal advice. If the disclosure is made by an arbitrator acting as a mediator, and this portion I will come to later, the disclosure is required by an order of court. The disclosure is required to assist a law enforcement agency. The disclosure is in compliance with a request by a regulatory authority. And the mediation communication relates to the commission of any offense under any written law or was made in furtherance of any illegal purpose. So in all these situations, you can share the information. So like we were discussing that day, let us say the Competition Commission wants this information, or SEBI wants this information can and should be provided. So I wanted to ask your impressions of this law. I discussed the Singapore law with a purpose because of the various grounds under which disclosure is allowed for mediation communication. So what are your impressions of this law?
Somewhere it is getting disturbed of the one of the idea of the arbitration, because one of the main reason for the arbitration is the parties, they'll be close to the like whole world. The information will not be leaked, like so that one of the main idea of the arbitration is that. So somewhere it is
mediation. You mean mediation?
Yes, ma'am.
And so somewhere that's getting disturbed.
Yes, ma'am. I feel so, at least sometimes.
Okay. Anil, you have your hand raised.
Madam, according to me, in whatever circumstances, Singapore law has provided for disclosing the facts and removing the confidentiality from this mediation. I think it is okay. It is perfectly fine in the larger interest of the society.
Larger interest.
It should be done.
Yeah, okay. So in the larger interest of society, when something is happening in a private dispute resolution process, but societal interests require it, so it is okay to share this, because you can see that the grounds all relate to public interest, public safety, economic interest. But Siddhartha says that somehow we seem to be losing the entire idea of confidentiality in a mediation, because there are so many exceptions to sharing of this information. Anyone
else? Cases in number will be very rare. It is not that in all and many cases it would have been asked by these agencies. Okay. Only hardly 1 out of 100 or 1,000 cases they may be asking. So I think exceptions are okay.
The exceptions are okay. Anyone who either agrees with Anil or with Siddhartha?
Madam, I agree with Siddharth.
Okay. That there are too many exceptions?
Ma'am, the
Doctor?
exceptions for legal and research are okay. Maybe because they are required after the case, like after mediation is completed.
Yeah, and that
Parties
is
come to a
anonymized
mediation.
also. That is
Yeah.
anonymized.
Once the mediation is completed and parties have settled. But
Mm.
for criminal, like what to say, for other cases, disclosing the information is like losing confidentiality will not give trust to the parties. So there will be no use, even if there is the provision to disclose the information. There is no use because nobody will be committing anything there. They'll be careful.
They'll be careful. So they're not going to share wholeheartedly.
Yes, yes.
Okay.
Ma'am, I would like to add point to Sandeep's conversation. What he says is, the parties will not be wholly turn up for the free mediation. There will be under some pressure mediation. What Sandeep wants to convey, generally, because
I understood Sandeep to say that people will not open up and share the information.
yes, ma'am.
So it will be a mediation where they're very careful, where they're very sort of withdrawn
Yes,
about what they say.
it's like cross-examination in a criminal case. Wait, what to answer, when to answer, what not to answer.
Yeah, possibly. Yes. People very, very cagey and careful. Yes. Any other view? Okay, so this is the reason why I always talk about the Singapore law. We talk about confidentiality, we talk about trusting us, we talk about safe space, but under the Singapore law, there are many, many things that come out. I think we all agree that confidentiality is not absolute. I think we all agree that. And I think when we were discussing earlier about should we have exceptions, when can we have exceptions, I don't think, correct me if I'm wrong, but my recollection is that no one said that it is an absolute thing. How come we have exceptions, right? So that's point number one. Point number two is if you are to have exceptions, you're obviously looking at either the interests of one or the other party or public interest when you are making these exceptions. But when we look at what different laws, so if you're looking at public interest, should public interest and what we identify as public interest not be the same in every country? It is not. It's actually a political question, right? How does the political economy of a country consider certain things? How does it regard offenses? Who does it give primacy to? A country like Singapore is very, very serious about any offenses, is very serious about regulatory default, non-compliance, and in its value system, confidentiality in a mediation will take a second seat to this kind of public interest or this kind of socio-economic or political economic interest, right? So it varies from country to country where you make these exceptions, right? One of the things that we saw in yes, Anil?
I think India is the most liberal country in the world as towards offenses and criminal cases.
Okay. So we'll see what India's law says, how it regards this. One of the points in the Singapore Mediation Act said that if, and I said I will come to it, it says that one of the exceptions to confidentiality is if the person disclosing the mediation communication is an arbitrator acting as a mediator. And arbitrator acting as a mediator under their Arbitration Act, they also have an International Arbitration Act. So under either of these laws, if the person who is an arbitrator is also acting as a mediator or a conciliator, then the information that the person is disclosing under that law is accepted from confidentiality. So I have shared as an example, I have shared with you the International Arbitration Act of Singapore. I've shared the link with you. So if you could open that, we'll just see what that law provides. And if you can also keep the Mediation Act 2023 open, I just want to show a certain comparison. Please let me know once you've opened it.
Ma'am, I could open this Indian Mediation Act 2023.
Huh.
I couldn't open this link which you're telling about. I don't know where the link it is.
Yukta would have shared it with you with the course outline. There I've given the link to the International Arbitration Act. Let me just
Acha.
check if it's there. Yeah,
This was in Word file, yes.
yeah, it's a Word file, and the link was there in that Singapore International Arbitration Act. Is the link not opening? I can.
It's opening now.
It's opening. Okay. Otherwise, I'll send the link once again.
No, it's opening.
It's opening. Yeah. Vijayanta has sent the link. Thank you. Okay, so if you can go, so this is the Arbitration Act that deals with arbitrations that are international in nature, that is parties from different countries. If we can go to section 16 of this law. So, do you all have it? Anyone who has not been able to open the act? Okay, so do you have section 16 in the act? Okay, we'll go to subparagraph 3. So, section 16 talks about appointment of a conciliator. Now, subparagraph 3 says, where an arbitration agreement provides for the appointment of a conciliator, and further provides that the person so appointed shall act as an arbitrator in the event of the conciliation proceedings failing to produce a settlement acceptable to the parties. So this section is looking at a situation where the arbitration agreement itself says that X will be appointed as an arbitrator, but this person will first be appointed as a conciliator, and this person will attempt to settle the disputes through conciliation. And if not, then go ahead and arbitrate the dispute, right? So in such a situation, no objection shall be taken to the appointment of such person as an arbitrator or to his conduct of the arbitral proceedings solely on the ground that he had acted previously as a conciliator in connection with some or all of the matters referred to arbitration. So, because the person has acted as a conciliator, the parties cannot say, no, he cannot act as an arbitrator. That kind of an objection, the law says you cannot take. Then we go to to section 17. This is power of arbitrator to act as a conciliator. 17.1 says, if all parties to an arbitral proceedings consent in writing, and for so long as no party has withdrawn his consent in writing, an arbitrator or umpire may act as a conciliator. So the person you've appointed as an arbitrator, or the person who is the umpire, if it is a 3-person arbitral tribunal or a 5-person arbitral tribunal, there is a presiding arbitrator or an umpire. This person can act as an arbitrator, after having acted as a conciliator, can go on to act as an arbitrator. So the person can take on dual responsibilities if all the parties have agreed. Paragraph 2. An arbitrator or umpire acting as a conciliator, A, may communicate with the parties to the arbitral proceedings collectively or separately, and shall treat information obtained by him from a party to the arbitral proceedings as confidential unless that party otherwise agrees or unless subsection 3 applies. So, information that you've got confidentially in a conciliation proceeding, you have to treat it as confidential unless the person who shared that confidential agreement says it's all right, you can disclose it, or if subsection 3 applies. So let us see what subsection 3 says. If a party agrees that confidential information has been shared, you can share it in the arbitration, there is no problem. 3. Where confidential information is obtained by an arbitrator or umpire from a party to the arbitral proceedings during conciliation proceedings, and those proceedings terminate without the parties reaching agreement in settlement of their dispute, the arbitrator or umpire shall, before resuming the arbitral proceedings, disclose to all other parties to the arbitral proceedings as much of that information as he considers material to the arbitral proceeding. So if confidential information has been shared with this person when the person is acting as a conciliator, and this person, there is no settlement, and the umpire or the arbitrator feels that certain information shared confidential will be useful for him to decide the arbitration, he can tell the parties, look, this is the information that was shared. I believe it is useful for the arbitration, and so I'm sharing it with you, and I will take this into consideration when I'm deciding the arbitration. Right? And paragraph 4, no objection shall be taken to the conduct of arbitral proceedings by a person solely on the ground that the person had acted previously as a conciliator in accordance with this section. You can't thereafter object that the same person had acted as a conciliator and as an arbitrator. What do you feel when you read this? What is your view?
It's almost the same dilemma. Yes, ma'am. It is the same dilemma will be there, moral dilemma, which we face in the MED-R model.
Don't say
where
MEDAB.
the information.
Don't say MEDAB model. Sorry, 1 minute, Anurag. Don't say MEDAB model, but you will say a model where MEDAB is done by the same person.
Yes, ma'am. That if that is the difference, I think then it will be. Otherwise, the MEDAR model itself is a little bit questioned, or a kind of a lack of trust is shown by people on this ground only.
On this ground, because if the same person is
So
being the
I think
conciliator,
it will on this ground.
yeah, if the
Because
same person,
smaller cases or smaller disputes. Yes, ma'am. Smaller disputes have so many issues when they gather around a table for mediation or conciliation or kind of thing. In bigger issues involving commercial transactions or contractor issues, there would be many, I think, spokes to the thing. So it would be little bit leading to complications or a kind of dissatisfaction or appeals arising out of this thing. So it's better, in my view, to stay clear of such through legislation.
through legislation. But Anurag, ironically, we are talking about a legislation that is allowing this.
Yes, ma'am. Legislation is dynamic in nature, except the few things. Chori karna paap hai, jhoot bolna paap hai. But somewhere it is allowed also, including God himself has justified sometimes in Mahabharata and other things. That's I mean to say the legislation, when encoded, when it is coded and hardwired, it has to be clear. Otherwise, it's okay, prone to, you can say.
Okay. Anil?
Madam, according to me, it is better to have different persons to act as a mediator and an arbitrator because to have an independent view of the same circumstances, set of circumstances that can be viewed by a different person in a different perspective.
Correct.
Even in medical science also, we take second opinion of other doctor, and many a times it happens that the other doctor differs with the first one.
Mm.
So it is better to have another person. It is okay that rule is provided, so nobody can object to it. But that is per force of the rule, per force of the law. It is better to have independent persons as mediator and arbitrator, in
Yeah.
my opinion.
Yeah. Yeah. Any other view?
Madam, I think that this provision is correct because during conciliator, as acting as a conciliator, he will be known all the facts about the case. So he can act as a good good arbitrator actually, in my opinion.
Okay. So if someone is saying, look, I do owe this money to this person, I will pay later. Why go round and round in trying to prove all of this? Because the person has said so, the conciliator has heard it. We are
Yes.
looking at doing justice to the parties, and so it serves that justice. That's another view.
Thank you.
But in all of this, what happens is that the safe space that we're talking about in mediation, we keep repeating safe, trust me, tell me everything, you can talk to me. That becomes a big question mark. Right? So, someone who would want, and I was talking to you about the Micro, Small, and Medium Enterprises Act. There, the micro or small enterprise will go to the Facilitation Council for conciliation, and if there is no settlement in the conciliation, the Facilitation Council will do arbitration. It could be the same person's doing it. That's what the law has allowed. People questioned it, saying, because if you looked at Part 3 of the Arbitration Conciliation Act, and I think it would be Section 74, if I'm not mistaken, that says that without the consent of parties, a person cannot act as both a conciliator and as an arbitrator, or as a conciliator and then as a lawyer for one of the parties. And the objection was taken by several parties before High Court, saying, look, this is what the policy of the law in the Arbitration Conciliation Act is, which says that two separate persons unless parties agree. Here you are saying the same person will be the conciliator and the arbitrator. That's problematic. I will share information that is confidential that could be used in the arbitration. You have a policy, now this is against it. Finally, the Supreme Court said, no. That may have been the policy in the Arbitration and Conciliation Act. In the MSME Act, this is the policy, and it's okay. There is no problem with it. Yeah. Venkatakrishnan?
Madam, there are two things that will be there. That which will be playing on the person who performs as a conciliator and the mediator as well as the arbitrator. One is, I will have a conflict of interest in my mind because I'll know many things that are there. And it may so happen, the psychology of humans is when I'm sitting on because arbitration is adversarial procedure, more or less. So then what happens is, as an arbitrator, when there is a kind of argument that is there between the counsels or maybe an expert or something that's coming in place, I may be tempted to ask this question if I'm an arbitrator. I'm just posing myself where I know the loophole there. As an arbitrator, I should not be exposed to certain things which are there. I should be only hearing a couple of things. I mean, I'm trying to say that you'll be tempted to look at or bring out some of those things in the space of argument on the heat of the moment. However, you may be, trying to be neutral. So that is something which is going to cause a problem to the arbitrator, I think. I mean, I don't know. This is what I'm foreseeing.
Yeah, I think you're right. It will, and I think Anil also made a reference to this. I think someone else also, Anurag also made a reference to this. It's going to cause a lot of quandary and sort of conflict in the mind of the arbitrator in both situations. Oh, what do I do with this information? Also remember how in Rineker versus the People, Rineker had argued so well and said that it's such a loose process, mediation, conciliation. People say certain things, people make vague statements, people make confusing statements, people may say something which they don't mean. You know, there is a lot of that happens. No one is under rigor of evidence in mediation proceeding. And so how seriously do we take these as admissions of liability? That was the point she made, and I think she had conveyed it very, very well. So you're right that this makes it difficult for the conciliator and the arbitrator as well. And we were, I referred to what the law said in the Arbitration and Conciliation Act in Part 3. Now, if we look at our Mediation Act, they want to stay away from this kind of controversy. And if you look at Section 17 of this Act, Section 17 says, the mediator shall not A. act as an arbitrator or as a representative or counsel of a party in any arbitral or judicial proceedings in respect of a dispute that is the subject matter of the mediation proceedings. B. Be presented by the parties as a witness in any arbitral or judicial proceeding. So that's a principle of confidentiality and privilege, that you won't present the mediator as a witness. So while the earlier policy that we had followed said that if parties agree, yes, you can be the conciliator and you can be the arbitrator. But this law now says you shall not. We don't put a person in this situation at all. This is in one compartment and this is in another compartment. And this is simply to avoid the conflict of interest issue. When we look at the Singapore law, it says, not only does it say you can be, it says if you have shared information, well, you can share it again. I mean, if you can share information, that information can be used by the arbitrator in deciding a matter. Right? Thank you for the different sort of points of view that you have shared. I think that really sort of addresses, I think not only in this, even in earlier discussions when we've had good points of view expressed by you that covers the full spectrum of things that we need to consider when we're making a law or making a policy on these issues, right? So that's important. We now go to, this is the last limb of confidentiality. We will go to the Uniform Mediation Act. Again, link was shared in the same document. Please let me know when you've opened it, and then I'll continue. I wanted to ask, most of the people in this group keep their videos closed. It will be nice if you turn on your videos so we feel like a classroom. It'll also be nice if you can participate, share your points of view in the discussion. I can know then if you're bored, I can know if you're finding this uninteresting, if you're finding it funny. It helps. We feel like we're in a class together. Okay, so if you've got it, this Uniform Mediation Act is something that comes from the United States of America. But before we look at it further, I just want to make a point that this is not a law, it is only a model law. So if you go to the first page, you find that there is something called, it says drafted by. the National Conference of Commissioners on Uniform State Laws. So the United States is a confederacy. The powers are distributed between the legislature at the central level, at the union level, as well as state legislatures. So many laws are within the domain of the state legislatures. And so you have 50 different laws on various aspects. If people are transacting, it could be marriage, it could be divorce, it could be buying and selling of goods, it could be online trade, it could be anything, right? Property in one place, person in another place, succession, right? What this National Conference of Commissioners on Uniform State Laws is not a government body. It's an autonomous body, and their effort is to standardize laws in the United States. So they make a model law on various aspects, and the idea behind it is, if we have uniform laws, uniform principles on certain things, then if I am doing something in another state, transacting with someone in another state, have a relationship with someone in another state, we don't need to worry about, is it the law in that state that is to be applied? Is it the law in my state that is to be applied? What is the law in that other state? Is it good? Is it bad? Right? We don't need to worry about those things, because there is certainty that this is the law. There is a uniform law, there's certainty that this is the law, and we're clear about our rights and our responsibilities or obligations under various relationships that we have. So their effort is to make uniform laws. So one of the model laws that they have made, so they make this law and then they leave it to the state. So these kind of uniform laws, again, I don't want to mislead, uniform model laws that are made after a lot of deliberation, a lot of discussion, a lot of consideration, so that all aspects, all considerations, everything that we need to take into account, they attempt to take into account. So even if you look at this, this is a 79-page document, and it's a document worth reading. It is 79 pages because in this model law on mediation, they have explained why they have defined or set out a law in a particular way, set out a section in a particular way. They've referred to judgments of courts earlier on this issue, and they've said we've tried to ensure that that aspect is considered, this aspect is considered. So this is a model law with notes on why the law is the way it is, right? So it's worth reading. So states are free to adopt with or without modifications these model laws. And several states in the United States have adopted this Uniform Mediation Act. So let's see what this says. So always bear in mind, this is a model law, this is not an actual law. It has a matrix-like approach to confidentiality in mediation. If you can go to the PDF page, because I think the pages are not, okay. PDF page 18 of 79. This is the first section. So section 1 says this act may be cited as a Uniform Mediation Act. Do you all have it?
Yes.
Okay, thank you. So then section 2 talks about definitions, and I'll read these definitions because they're important. They indicate how much thought is given to this aspect. Mediation means a process in which a mediator facilitates communication and negotiation between parties to assist them in reaching a voluntary agreement regarding their dispute. 2. Mediation communication means a statement, whether oral or in a record or verbal or non-verbal, that occurs during a mediation or is made for the purposes of considering, conducting, participating in, initiating, continuing, or reconvening a mediation or retaining a mediator. So if you look at this definition of mediation communication, it is very wide in the different things that it covers. all communications that relate to starting a mediation, reconvening a mediation. So emails that may be sent saying our next session will be at this place, this time. Non-verbal communication, what you observe a party doing, someone crying, someone nodding, shaking their head, everything is mediation communication. Okay. So if a party says something and the counterparty is nodding vigorously, it means, I mean, what we immediately understand would be that they are in agreement or they're confirming what has been said. And this communication can be important, right? So this is the definition of mediation communication. Then you have mediator, who is an individual who conducts a mediation. Non-party participant means a person other than a party or mediator that participates in a mediation. So I was talking to you about advisors participating in the mediation, mediation case managers who will be sitting in the mediation. You could sometimes we have law students who are interns who come and sit in the mediation, watch the mediation, right? Shadowing the mediation. So that's a non-party participant. They are not interested in the dispute. They are participating for a different reason. Mediation party means a person that participates in a mediation and whose agreement is necessary to resolve the dispute. So these are persons who are interested in what is being discussed and who will be interested in what the agreement will be, right? So we keep these definitions in mind. And then we go to section 4. This is in page 31 of 79.
Ma'am, which section?
Section 4. This is page 31 of 79. The language is a little confusing in the sense that it goes back and forth a bit, but it's actually quite simple. It's a matrix of responsibilities and sort of powers that people can exercise. Right? Do you have it? Yeah. So section 4 deals with privilege, against disclosure, admissibility, and discovery.
Excuse me, madam.
This will be page 31 of 79.
Somewhere it is on 26th page, madam. When I have
Okay, I'm not sure why that is, but yeah.
yeah.
But
I
so
have
long
taken printout of this, and it is on 26th page.
26 page. Okay, on PDF, it's 31. If you're scrolling on the PDF on your screen, it's 31 of 79, unless someone is finding a different page. I think in printing it out, maybe a different pagination has come.
But 79 pages also not there, madam.
Okay. So do you all have it? Section 4?
Yes.
Other than Krishna Kumar, because for him it's easy. Okay, so section 4 says privilege against disclosure. Privilege is my right to tell the court or the handicap on the court or an arbitrator to ask for certain information to be produced. That is privilege. I can say no, and the court does not have the power to compel me. Admissibility is a rule of evidence. Again, it says certain types of information, documents can be produced. For instance, to give you an example, a Xerox of a document you cannot produce. A photocopy you cannot produce. I mean, that's the typical norm. And the third is discovery. Now, if I know that there is certain information that is available with the other person or persons to the case, I can ask that person to produce that information or produce that document through discovery. I ask a question, did this happen? Do you have this document? Was this signed? And that person will have to answer yes, no, truthfully and produce that document. So these are the rules can you, we don't use discovery as much in India as it is used in the United States. It's used very, very extensively, discovery, right? So what does it say about this? Except as otherwise provided in section 6. So we'll need to see section 6 to get the full picture. A mediation communication is privileged as provided in subsection B and is not subject to discovery or admissible in evidence in a proceeding unless waived or precluded as provided by section 5. So as a norm, all mediation communication is privileged, right? There is an exception in section 6 and there is provision for waiver in section 5. In a proceeding, B, in a proceeding, the following privileges apply. A mediation party may refuse to disclose and may prevent any person from disclosing a mediation communication. So all mediation communication that has been made in a mediation, whether it comes from a party, a participant, a mediator, the mediation party may say, no, it cannot be disclosed in the court. A mediator may refuse to disclose a mediation communication and may prevent any other person from disclosing a mediation communication of a mediator. Insofar as a mediator is concerned, the mediator can prevent anyone from disclosing something that the mediator said or did. Any mediation communication from the mediator, they have the last word in saying, no, this cannot be disclosed. Similarly, a non-party participant may refuse to disclose and may prevent any other person from disclosing a mediation communication of the non-party participant. So if I'm a lawyer for one of the parties, I'm sitting there, I've said something, done something, some communication from me. If it sought to be introduced in the legal proceedings, I can say, no, it can't be. Okay. Evidence, now I'm in C. Evidence or information that is otherwise admissible or subject to discovery does not become inadmissible or protected from discovery solely by reason of its disclosure or use in the mediation. We saw this in the Ireland Act and Singapore Act. If there is information that relates to the, supposing there is a bounced check, simply because it has been brought and discussed in the mediation, or because the party, one of the parties has said, look, this person's check bounced. It doesn't mean you can't bring that bounce check to the case because it constitutes evidence in that case. It doesn't relate exclusively to what has happened in the mediation. Okay. Now we come to section 5. This is in page 37 of 79, and at the bottom there are pages, page numbers in each page. It is 20 at the bottom of the page. So section 5 talks about what each of these persons can do, what the mediator can do, what a party can do, and what a non-party participant can do. So it's waiver and preclusion of privilege. A privilege under section 4 may be waived in a record or orally during a proceeding if it is expressly waived by all parties to the mediation. So if everyone agrees, all parties to the mediation agree, you can exclude it. But if it is relating to communication by the mediator, it has to be waived by the mediator. If it is relating to a non-party participant, that non-party participant has to expressly waive it. Right? If you look at the converse, supposing a non-party participant has said something, there's a mediation communication in the mediation, and that person says, it's okay, I'm waiving it, let's discuss it. You can bring it up in the case. You can't unless the parties to the mediation also, all of them agree. So they have sort of the preeminent position. They will finally decide if information can be brought into the mediation or not. So because the mediator says, okay, bring in my communication, you still cannot do it. You know, I could be the mediator and I say, no, that's okay, we can bring it up in the case. It doesn't matter that I have said it's okay. It doesn't matter that I have waived. The parties must also waive because it is their rights and their interests that are going to be affected by any of this communication, right? Now we come to B. A person that discloses or makes a representation about a mediation communication which prejudices another person in a proceeding is precluded from asserting a privilege under Section 4, but only to the extent necessary for the person prejudiced to respond to the representation or disclosure. If I have said something about a mediation communication, if I have said, look, X, who's the lawyer for one of the parties in the mediation, said this. Now the lawyer can say, well, I said it because you said something. I said it in response to what you said. Now, when this lawyer wants to talk about what the other person said, because what he has said in the mediation has been disclosed, the other party cannot say, no, this is what I said, I have privilege, I have confidentiality, you cannot talk about it. Well, then the law or this principle says that you brought it up. So to the extent I need to respond to what you have said, or to explain why I said a certain thing or behaved in a certain way, your privilege will no longer be there. So they are precluded from asserting a privilege under Section 4. Okay. Then we'll go to Section 6. These are exceptions to privileges. So this talks about situations when privilege will not apply, whereas Section 5 talked about the right of a person to waive. So Section 5 is focused on the person concerned. Section 6 on situations when there will be an exception to privilege. This is at page 40 of 79 or internal page 23. Okay, so exceptions to privilege. A, there is no privilege under Section 4 for a mediation communication that is 1, in an agreement evidenced by a record signed by all parties to the agreement. If you've said something, if you've conceded something, if you've made a proposal, but finally that has been recorded in a mediated settlement, then there is no longer any exception, there is no longer privilege. Is available to the public under, and in box brackets you see the language, insert statutory references to Open Records Act, or made during a session of a mediation which is open or is required by law to be open to the public. So open records law is similar to our right to information law, where certain records relating to the police or to the government, state, public functionaries should be available to us to access and see. So that's their Open Records Act. This also talks about certain kinds of mediation that are held in the open, where public participate or are required to be held in the open. Examples of this could be if this relates, let us say, to a mediation relating to a housing dispute, that is a housing project, a public project, an environmental dispute where public are interested, or a dispute where the government or state is a party. In such mediations where it's open to the public, then there is no privilege that attaches to any communication made here. 3, is a threat or statement of a plan to inflict bodily injury or commit a crime of violence. So if there is communication that relates to a plan or a proposal to harm, then there is no confidentiality. The mediator or another party can take recourse to police or other authorities to safeguard their interests. 4, intentionally used to plan a crime, attempt to commit or commit a crime, or to conceal an ongoing crime or ongoing criminal activity. Similar principle. 5, is sought or offered to prove or disprove a claim or a complaint of professional misconduct or malpractice filed against a mediator. So the mediator has misconducted themselves in the mediation. You can still bring up the mediation communication that related to the misconduct, because you have a right to safeguard your interests to complain against misconduct by a mediator. 6, except as otherwise provided in subsection C, sought or offered to prove or disprove a claim of complaint of professional misconduct or malpractice filed against a mediation party, non-party participant or representative of a party based on conduct occurring during the mediation. So if they've behaved in a bad way, if there is professional misconduct, say by a lawyer or an accountant who's advising these parties, for that you can use it. 7. Sought or offered to prove or disprove abuse, neglect, abandonment, or exploitation in a proceeding in which a child or adult protective services agency is a party. Right? So, and they provided exceptions which the states can introduce, which they can consider and introduced. So, if it concerns a child or an adult who is under protection, maybe the person is very old and therefore is under an adult protection agency. This kind of information on abuse, neglect, cruelty, that can be brought into the mediation. Then B, there is no privilege under section 4 if the court, administrative agency or arbitrator finds after a hearing in camera that the party seeking discovery or the proponent of the evidence has shown that the evidence is not otherwise available and that there is a need for the evidence that substantially outweighs the interest in protecting confidentiality and that the mediation communication is sought or offered in a court proceeding involving a felony or except as otherwise provided in subsection C, a proceeding to prove a claim or rescind or reform or a defense to avoid liability on a contract arising out of the mediation. Does this remind you of something, this rule? Did you see this rule anywhere else? This is the Rineker rule, right? So it's sort of the modification of the Rineker rule where where the court said that what happened in the mediation can be compelled to be disclosed because we are interested in a fair trial for juveniles or young people, right? So the need for the necessary or justice necessitating the information to be shared outweighs, is more important than keeping it confidential, right? Then C, a mediator may not be compelled to provide evidence of a mediation communication referred to in subsection A6 or B2. So A6 relates to professional misconduct, right? Now, you cannot compel the mediator to talk about what they said or did, right? Because they should be entitled to defend themselves and not have to say certain things. So they don't self-incriminate themselves, therefore there is an exception. And B2 is where it relates to a settlement agreement and what they have decided or how it's to be interpreted or what's to be done. If there is a question on that written settlement agreement, the mediator is not going to talk about it. So you cannot compel a mediator. Again, it says, this is D. I'll just summarize it. It says that you have exceptions to mediation privilege, but the exception, how much of information you will share, should be linked to what needs to be shared. Simply because it is an exception doesn't mean you share everything that was said. Only to the extent you need to meet those principles in paragraph A of section 6, only to that extent you will disclose information. Section 7 deals with what information will be given in a mediator's report, the extent to which you can share, not share. So it says that, and this is at page 51 of 79. It says A, except as required in subsection B, a mediator may not make a report, assessment, evaluation, recommendation, finding, or other communication regarding a mediation to a court, administrative agency, or other authority that may make a ruling on the dispute that is the subject of mediation. This was something we considered in the Perikansagara case. Right? This was something we discussed. Should a mediator make a report? What should the mediator say? B, a mediator may disclose whether the mediation occurred or has terminated, whether a settlement was reached, and attendance. So who participated? Was there mediation? Is it still continuing? This is information you can share. The mediator can disclose a mediation communication permitted under Section 6. So Section 6 are the exceptions to the privilege. The mediator can share this information. 3, a mediation communication evidencing abuse, neglect, abandonment, or exploitation of an individual to a public agency responsible for protecting individuals against such mistreatment. So if the mediator finds in the course of this discussion that there is abuse, neglect of a person, of a child, or of an elderly person, or a person who is infirm otherwise, and therefore you have government protection agencies who are there to take care of such persons, and the communication shows that there has been neglect or abuse, then this is information the mediator can share with this government agency. C, a communication made in violation of subsection A may or may not be considered by a court, administrative agency, or arbitrator. So if the mediator makes an evaluation or an assessment of the case in their report, the court will decide whether they want to look at it or not look at it. It's a little strange because it says that you cannot make a report. It says you may not, make a report. And then it says if a report is made, it can be considered by, in violation of the subsection A, if a report is made, the court may consider it. So this is what the Supreme Court did in the Perikansagara case. So this broadly is what the Uniform Mediation Act deals with. So it starts, unlike the other laws, with making a point that everything is confidential. I mean, mediation communication, is confidential. It sees who are the different people who are involved in the mediation. First is a mediator, second is the parties to the mediation, third is the non-party participants to mediation. And then it draws rules about who has the right. It makes the first rule that it will not be shared. There is privilege that will attach. You can't ask for this information to be provided. And it talks about waiver. So the preeminent position for waiver is that with parties to the mediation, they can say no to any information. But if they agree to some information being shared, which is they waive and say certain mediation communication can be shared. If it is coming from the mediator should also agree. If it's coming from non-party participants, they must also agree. Only then such information will be made available to the court. It also gives exceptions to when there is no privilege that attaches. And it also talks about what a mediator can say in their report. Right? So this is the framework. There are further sections. Those relate to international mediations. We don't need to look at it because we're only considering when do you allow mediation communication, when do you prohibit, what is the rule of confidentiality. That is what we are discussing. So this is a very different way of approaching policy making for confidentiality. The focus is only confidentiality in this uniform mediation law. It doesn't talk about voluntariness. It doesn't talk about mandatory mediation, none of that. It's only concerned with how do we keep mediation communication confidentiality. What is the rule? Right? So that's what this law talks about. So we've looked at 3 policies. We look at the Mediation Act next. We'll take a break now at 6:03. We'll rejoin at 6:10. Okay, so I'll start. If you can open section 22 of the Mediation Act, our Mediation Act. So sections 21, 22 and 23 talk about confidentiality and privilege, but we will start with section 22 first and then go to 21. So section 22, confidentiality, can I start? Yeah, okay. Subject to the other provisions of this act, the mediator, mediation service provider, the parties and participants in the mediation. So you can see similar language, right? Parties, participants in the mediation shall keep confidential all the following matters relating to the mediation proceedings, namely acknowledgements, opinions, suggestions, promises, proposals, apologies, and admissions made during the mediation. 2. Acceptance of or willingness to accept proposals made or exchanged in the mediation. Documents prepared solely for the conduct of mediation or in relation thereto. Any other mediation communication. Now, what is mediation communication? It's defined in, section 3, subsection K. So if you go to the beginning of this act, that has the definition, section 3, subsection K. That says mediation communication means communication made whether in electronic form or otherwise through anything said or done, any document or any information provided for the purposes of or in relation to or in the course of mediation, and includes a mediation agreement or a mediated settlement agreement. So if you have an agreement where you say, if we have disputes, we will take it to mediation, that's expected to be confidential. Why? I don't know. We saw cases in England where if there is a mediation agreement, the court is saying, please go for mediation. And for the court to say, please go for mediation, you must show them the mediation agreement. Here it says the mediation agreement is confidential. It also says that a mediated settlement agreement is confidential. Again, I don't know why. Okay, but if you've had any communication that relates only to the mediation, that was made only in relation to the mediation, that was made only for the purposes of the mediation, then this communication will be kept confidential. So apart from this kind of mediation communication, if we go back to section 22, any acknowledgements, any admission that you make, any concession that you give, any proposal that you give, any ideas on how it can be settled that you give, all of that will remain confidential. Okay. Then we go to paragraph 2 of section 22. No audio or video recording of the mediation proceeding shall be made or maintained by the parties or participants, including the mediator and mediation service provider, whether conducted in person or online, to ensure confidentiality of the conduct of mediation proceedings. Okay, so this is clear. 3. No party to the mediation proceeding shall in proceedings before a court or tribunal, including arbitral tribunal, rely on or introduce as evidence any information or communication set forth in clauses 1 to 4 of subsection 1 including any information in electronic form or verbal communication, and the court or tribunal, including arbitral tribunal, shall not take cognizance of such information or evidence. Okay, so one, you don't share this kind of information before the court, and two, the court will not take any account of this information. 4. The provisions of this section shall not prevent the mediator from compiling or disclosing general information concerning matters that have been subject to mediation for research, reporting, or training purposes if the information does not expressly or indirectly identify a party or participants in the specific disputes in the mediation. So I may want to put out my profile where I say I have mediated 50 divorce cases. I have mediated 20 partnership disputes. I can do so because I'm not identifying who they are. I am talking about the type of dispute that's there, but in a very general way, where you are not able to identify who the parties are. Then we see the explanation. For removal of doubts, it is hereby clarified that nothing contained in this section shall apply to the mediated settlement agreement when its disclosure is necessary for the purpose of registration, enforcement, and challenge. If you want to enforce that mediated settlement agreement, it doesn't remain confidential. You want to question it, it doesn't remain confidential. Okay, so this is the rule regarding confidentiality. Then we come to section 23, which is admissibility and privilege against disclosure. No mediator or participant in the mediation, including experts and advisors engaged for the purpose of the mediation and persons involved in the administration of mediation, shall at any time be permitted or compelled to disclose to any court or tribunal or in any adjudicatory proceedings by whatever description any communication in mediation, or to state the contents or conditions of any document or nature of conduct of parties during mediation, including the contents of negotiations or offers or counter offers with which they have become acquainted during the mediation. So you cannot compel these people to do it, to share. There is nothing here on waiver of privilege, no rules regarding that. Provided that nothing in this section and section 22 shall protect disclosure information sought or provided to prove or dispute a claim of or complaint of professional misconduct of mediator or malpractice based on conduct occurring during the mediation. So it's also for misconduct of the mediator or of any other professional, there is a malpractice that happened during the mediation, you can share that information. There is no confidentiality. 2. So these are now the exceptions to privilege and confidentiality. There shall be no privilege or confidentiality that will attach to a threat or a statement of a plan to commit an offence punishable under any law for the time being in force. If there is a threat to commit or a statement of a plan to commit, you will not disclose. I just want us to compare this with the language in the Singapore Mediation Act. The Singapore Mediation Act says that you can disclose if there are reasonable grounds to believe that the disclosure is necessary to prevent or minimize the danger of injury to any person, or the abuse, neglect, abandonment, or exploitation of any children or young person. So something is happening and you want to prevent it or minimize it, then you can share it. Whereas here it is a threat or a statement or a plan to commit an offence punishable under any law for the time being in force. Often you see that passions run high during mediation, anger, hurt, and people say things. So will that be covered by this section? Second, information relating to domestic violence. This is B I'm reading. Information relating to domestic violence or child abuse and statements made during a mediation showing a significant imminent threat to public health or safety. The way the language is worded in this places a lot of responsibility on the mediator, right? And places a lot of responsibility or power also on other parties on what they can do when these situations happen. It's going to take integrity, and it's going to take a lot of responsibility and reflection on the part of the mediator to be able to assess, is this serious? Are they just idle threats? Are they simply saying things? Make this assessment and then decide whether this needs to be reported, informed to someone else, right? Mediators, I know some who have come across, I too have come across situations where the parties in private sessions disclose abuse, abuse of children particularly, abuse of the spouse or partner. It then becomes, under this law, a matter of responsibility. What do we do about this? Should we report this? Who do we report this to? So these are fraught, very difficult situations, and like I said, we need integrity, we need some amount of reflection, a very responsible action to be taken by the mediator and other persons who are sitting in the mediation when this happens. Okay, so that's this next. The last is section 21, which says, subject to the provisions of section 26, where no agreement is arrived at between the parties within the time period as provided under section 18, or where the mediator is of the view that no settlement is possible, he shall, in the case of institutional mediation, submit a non-settlement report to the mediation service provider in writing. In all other cases, prepare a non-settlement report and provide a signed copy to all the parties. And this last paragraph is what we are concerned with. Provided that the report referred to in this section shall not disclose the cause of non-settlement or any other matter or thing referring to their conduct during mediation. Your report will only say not settled and send it back.
Madam, it will be only one line report.
Possibly.
Mediation failed.
Possibly. It could also say we met on all these days. We had mediations on 3-4 days, whatever it is, you can say that. You can also, sorry, yeah.
Yeah, one small doubt, ma'am, regarding section 23, exceptions. Ma'am, suppose the mediation process is going on and one of the parties says that and admits that we have in the past committed this offense or crime, but now the parties are knowing each other and they know that the party A is agreeing with that offense, but ultimately they are ready for a settlement. But so in that case also the mediator will have to disclose that fact, or only for the future cases, like I will do that, I will do this, only in those cases, because both are different.
Yes, it is only for future cases that you have a thing, because it says to commit an offense, and C says statements relating to showing a significant imminent threat to public health or safety. That's likely to happen. But if it relates to domestic violence or child abuse, then you have to report. Otherwise, you don't. But you raise a more serious issue when people are talking about offenses that they have committed and this is what they have done. Should the mediation continue? Because by allowing these discussions and the settlement on the basis of what they have done, which is an offense earlier, it's better to stay out of that mediation, to close the mediation, leave it to the parties to work out what they are doing. But you don't have an obligation to disclose if this is a past offense. You have an obligation to disclose if the other law says that you have to disclose. For instance, the Prevention of Commission of Sexual Offences Against Children, the POCSO Act, makes it a responsibility, a legal responsibility on any person who has information that child sexual abuse had taken place to report it to the police. So that's the law, and this law we have to, they don't match. It does talk about information relating to child abuse. So there is a responsibility for you to report anything. So, but there could be other laws, not this law, sorry, other laws where there may be a requirement to report, but we'll need to see what this law says and what that says, and we must see what the courts decide about what the responsibility of the party will be or the mediator will be.
Yes, ma'am. Ma'am, one more thing. While starting of this mediation, should a mediator say that for these exceptions, in case I found that these are the points, if anybody is found with respect to these points, so I will disclose that in advance. Can he tell both the parties?
Okay, that's a good question. The law says this, and therefore parties are expected to know these exceptions. That's point number one. Point number two, it still is the responsibility of the mediator to tell the parties that, look, when we talk about confidentiality, it applies only to these kind of situations, right? So a party shouldn't think, for instance, that they bring some document in the mediation, now it's covered by confidentiality and they can't bring it before the court. That's not the case. If evidence relates to a case, simply because it has been discussed in the mediation will not stop the party from taking it before court. So it is our responsibility as mediators to tell the parties that this is the scope of mediation, that there are these exceptions. If you tell them that there are these exceptions, it's good, because not everyone comes to mediation knowing what the law is, though the law expects them to know it. So it is good for us to, talk about these things. In fact, on the basis of this Uniform Mediation Act, there is this professor of law and mediation who has made a video, and this his name is James Coben. You can search for it online. He says how difficult telling parties that there is confidentiality in what you discuss in the mediation becomes. Because in his thing, he says, you can say this, but this, it's not there. You can say this, but this, it's not there. He makes it like a joke. Because we often tell parties, oh, whatever you discuss here is confidential. That may not be accurate. So, yeah, we can, be very clear in how we communicate what the confidentiality relates to. Hemangi?
When just now we are talking about which facts to be disclosed and which not to be disclosed. Say, for example, child abuse case, we have to disclose to the police. But if settlement agreement is going on and it is decided by both the parties, the settlement agreement to be executed, still we have to disclose this fact to the police. In that case, what is the use of the settlement? The party may not agreeing or they may not be satisfactory on this mediation process.
So this confidentiality in mediation actually is fraught, and it's a very difficult sort of a thing. Assume they've discussed child sexual abuse that has been revealed, and the agreement is that the child will go to the parent who has been committing this. How would we as a mediator feel about it?
Being a mediator, it will not be good for a child's future.
That's right. Do we have a responsibility?
Yes.
So I think we need to think through those things when situations like this come up.
That we have to mention it in settlement agreement itself that this type of things have happened.
No, we can't say that. It's the parties who decide what is going to be said in the settlement agreement. We can't say that. But we must contemplate whether this is something that should be settled in a mediation. I know people who have sort of asked for a therapist or a psychologist to come and sit with the child to see if, to assess what has happened, or reported to the court when this has happened. In a court annexed mediation, they've reported it to the court. But once information like this comes out, then continuing with the mediation must be sort of reconsidered very, very seriously. So at that point in time, the fact that they are settling becomes secondary. I mean, this is my view. This is not a legalistic or whatever view. This is my view.
Sometimes we have to act upon the morally also and ethically also. So we have
Sorry,
to
say that
consider all
again.
these aspects ethically and morally. So we have to consider all these aspects when particularly we are acting as a mediator. We have responsibility. It is not just like any particular position that we have to face the matters and we have to go for the settlement just to resolve the dispute. We have to consider all these aspects.
Yeah,
That is
yeah.
true.
What you say is absolutely right. Yes, it becomes
Thank
very
you.
difficult. Yeah, thank you. Okay. Any questions, any observations about this? With this we close on confidentiality.
Ma'am, there is a question regarding confidentiality part. We have talked about the regulatory bodies or the court or some documents falling into the public domain once the settlement is arrived at. But there is one dimension still left. Can Parliament seek the documents or details related to a mediation? This thought has come up from because a sitting legislator was into some kind of dispute, and I will quote only a single line from my written communication to him that try to reduce your baggage, don't put it into the public domain this way. So he was a little bit worried, though there must be some kind of rules regarding the questions in parliament on personal traits or personal life, but little bit he was worried. So can parliament seek like other information except which is against national interest, broadly it is said?
You're saying parliament, or you mean through a law?
Parliament. Say some question is raised about a dispute. I'm not talking about the small disputes. Let us say the Reliance Amazon deal.
I am
that
not
was
able to answer that question. I don't know if Parliament has that power.
Because all the laws we discussed, nowhere this word or this dimension was discussed. I think it is silent about this.
No, so that's precisely what I'm trying to say, Anurag. If you talk about power of the Parliament, I really don't know. I don't know what the powers of the Parliament are to summon or to ask for some document. I'm not aware of anything like that. That's why I asked you a question. Are you talking about when they pass a law, or do they have the power as is? I don't know. I don't.
No, Parliament. I meant, ma'am, like say some parliamentary committee is there.
Yeah, I know. I'm not aware of any such powers that they have. So I'm not able to comment on it because the answer is simply that I don't know. To my knowledge, they don't have such powers, but I can be very wrong. I don't know. But a place where you can look at this kind of things is the Personal Data Protection Act and the power of the government to ask for information. That's a place where you can search to see if there are exceptions to this. The ability to ask for, yeah. Keshav?
Ma'am, just to pinpoint on Himangi ji's observation, there is a recent Kerala High Court judgment where they said there cannot be a settlement when it comes to POXO cases, prevention of sexual harassment against children. So now, slowly and gradually, even courts are taking this position that you cannot have any kind of settlement when it comes to any kind of crime against women or children. So just wanted to add on that particular
Thank you
bit.
so much. That's useful. And I'll also tell you that in the Madras High Court, many years ago, there was a girl who had been raped, and she said, "Look, this has happened," and there was a case filed against the perpetrator. Perpetrator was convicted, and then the judge says, on an appeal, a High Court judge said, "Why don't you all try mediation and see if you can resolve it, if you can settle something?" And as mediators, we all objected. We said this is not done. And we had some senior mediators in our midst who raised this as an issue. More recently, we have another judgment of the Madras High Court where there has been a rape and the person is convicted, and the court also says, so this person, she has a child, and then she apparently has a child with this man again. And the court says, look, why don't you all discuss and settle it? So, you know, there are all kinds of orders passed on the basis that, you know, mediation is available. So we need to be very careful about when we use mediation. And that's a topic we'll discuss. We'll see what the law says about this. But clearly, yes. But thank you for that information. That's good to know. Himangi, you had another.
Yes, ma'am. In this case, in many of the cases of domestic violence, we have seen, even rather, I have also seen that some judges are referring these matters to mediation and can't be at that stage only stop this or say to the court or showing the judgment to the court that this is not a valid thing or legal thing. We are wasting our time in that. Can't we do that? Being a lawyer on behalf of that lady or woman.
Can we not do what? Say that it should not be sent to mediation?
For example, if I am a lawyer on behalf of that wife who has been abusive, face that abuse of domestic violence. The case is going on before the court, and court is asking to go before the mediation for settlement.
Yeah, of course you can object. But the Mediation Act says that if it involves criminal offenses, unless they are compoundable, you can't send it for mediation. But till this act comes into force, people are sending disputes for mediation, domestic violence disputes for mediation. In fact, if you look at the Domestic Violence Act, the rules, they talk about settlement.
Yes.
So, how seriously we view these kind of offenses?
It means there is a lot of contradictions.
There is a lot of
Contradictions in the statute itself.
Yes, absolutely. Swati? Swati, did you have a question? So, Himangi, there are a lot of writers, in case you're interested. There's someone called Trina Grillo, I think, Laura Nader. They talk about how these are hard-won rights for women against domestic violence, getting the police and authorities to acknowledge that there is domestic violence has been such a battle. Can you send these kind of disputes to mediation? And they've written about it. So you can look for information and read. That will give you more perspectives on this. Swati, do you have a question? Okay, so let's, Anil?
Yes, for mediator also, it is voluntary to act as a mediator. He can refuse to act as a mediator if he is not convinced about the case.
That's right. Absolutely. So in these kind of situations, you're saying, Anil, that I can say I don't want to be a mediator anymore. Yeah.
Definitely, why to involve in a problem?
Yeah,
of such nature, which is against my conscience.
absolutely, absolutely. That's the first thing about mediator we must acknowledge. Okay, so we'll move on to the next topic unless anyone has any questions about what we've discussed so far on confidentiality. We'll move to the next topic. Okay. So this topic is sort of a twin topic, and this topic relates to and they're interrelated. Topic relates to there is a mediated settlement agreement. Should we give this mediated settlement agreement any sort of special status, any special enforcement? That is, when I say enforcement, okay, Swati has put it in the chat. Can an RTI application be filed to disclose mediation proceedings? No. Sorry, it's a yes and no. No, because if it relates to, say, a matrimonial proceeding or whatever, we already have, there is a reported order of the commissioner, which says that where one of the parties to a matrimonial proceedings wanted information about what had transpired in the conciliation, the record, and they said, no, it cannot be. This is private information. There is no sort of you don't have a right under the RTI Act to ask for this information. But let's take another situation where there is a contract between the government and, say, someone who has built a port or someone who has built a road. And all these disputes are now taken for conciliation. Now they go for conciliation and they settle it. You and I as public, can we not ask for that information? What were the terms on which you settled? What was the claim? What did you settle for? Because there is a public interest in knowing how this matter was settled. So I would think that that's something you can ask for information on, right? And so that's what's covered in the Uniform Mediation Act that the US, the model law of the US has. It talks about Open Records Act. Our law doesn't say anything so far. We go by the exceptions that are provided to non-provision of information under the RTI Act, and we have to see what happens. These are sort of open areas. I don't know if you all know, I have written a book on mediation, and this book deals with the use of mediation in different sectors. So one of the chapters that I deal with is government disputes. And there I talk about, is it possible to, in government disputes, is it possible for parties to, or general public to ask for information about it? What happens between the Right to Information Act and confidentiality in mediation? The book is called Mediation Policy and Practice. Right? So there I've discussed a little more about what these issues are. Okay, so we'll go to status of a mediated settlement agreement and challenge to a mediated settlement agreement. So when there is a settlement agreement, what is the status that it has? Is it like any other agreement that people make? Or should we give it a little more sort of weight and authority? Should we sort of say that, okay, this agreement, the government or the state or the courts will take this a little more seriously and enforce it? Or should it just remain as an agreement? When we looked at when we look at the Ireland Mediation Act, that says you enter into a settlement agreement, it's like an agreement, nothing more. If you look at the Singapore Act looks at it in two ways. The Singapore Act looks at mediators as those mediators who are certified or trained under the Singapore regulations. And it also looks at other people who may act as a mediator, who may be mediators in certain disputes, but they are not trained, they are not certified. And the Singapore Act says, if any settlement agreement that you enter into in a mediation is like an agreement, is like a contract. But if the mediation is conducted by someone who is a certified mediator, then if all the parties agree, they can apply to the court and say, look, we had a mediation. It was done by a certified or a trained mediator. And this is a settlement agreement we arrived at. We want you to look at this settlement agreement and make it like a decree of court. Give your stamp of approval to this agreement. And in such a situation, the court will look at this mediation. They will evaluate it. And if they're happy with it, if they think it's okay, then they will pass an order as if this settlement agreement is a decree passed by the court or a judgment passed by the court. This means that you can immediately execute it. You can go straight for execution too. You don't have to, in an ordinary case, if I have, let us say, a settlement agreement, which is only an agreement, right? No court has looked at it, nothing has happened. I have a settlement agreement. Now, if the other person to the settlement agreement does not implement the settlement agreement, then I will have to go to court. And of course, I ask, come on, you agreed, we agreed to this, please do it. But if it's not done, I need to go to court. I file an application in court or a suit in court and say, look, this was the relationship, this was our commercial arrangement, whatever it was. We had this is the dispute we had, then we tried to settle it through mediation, we settled it in mediation, and this is the agreement we had in mediation. Now this person is not doing what they are supposed to do under the agreement. Please pass an order saying that they should do what they had agreed to do. Now look at all the steps I have to take in the case. I have to say there was this commercial relationship or personal relationship, not personal, sorry, commercial relationship or other legal relationship. There were disputes. We had a mediation. X was the mediator. At the end of the mediation, we settled. This is the settlement agreement. Now enforce it. I have to prove all of this step by step by step. I have to prove all of this. Then if the court is satisfied, yes, the court will say, look, you agreed to do this in the settlement agreement. Please do as you had agreed. Now, if we take the Singapore case where it is mediation conducted by a certified mediator and there is a settlement agreement, I take it to the court reviews the agreement on certain basis and says, okay, I think this is okay, there's no problem. It will pass a decree. Now, I immediately, if the person is not performing, doing what they're supposed to do or implementing the agreement, I can go straight to an enforcing court and say, he did not pay this money which he was supposed to do under the agreement. Please make him pay that money. This is execution. This is enforcement of that agreement. The court will say, all right, please come, you had agreed, pay the money. And if the person doesn't pay the money, they're only going by the settlement agreement and the order passed by the court. That's all. They're not going behind it, no questions asked, nothing. So they say, pay the money. If the person doesn't pay the money, then they'll say, you have this car, we are attaching this car. If you don't pay the money, we will sell the car and get the proceeds to pay this person. Now, the question is, how should we regard a mediated settlement? So that's the policy in Singapore. But back to the question that we need to ask ourselves, how do we regard such a settlement agreement? And number two, related to this, if a person has a problem with the settlement agreement, so the other person who is not implementing it could do it because they don't care or they are not able to, or that they have a problem with the settlement agreement, which is why they don't want to implement it. Can we allow someone to question the settlement agreement or challenge the settlement agreement and say, I'm not going to implement it because of these reasons? So what are your views on this? One, should the settlement agreement be given a slightly exalted or higher status? Two, can a person who is a party to the settlement agreement question the settlement agreement? Next, can a third person question this settlement agreement? What do you think? Anil, you had, I don't know if it relates to this or...
No, I was simply asking for court stamp whether one party should approach the court or both the parties have to approach the court.
Need to. Or one does with the consent of the other person.
Yeah.
We'll go through that. We'll go through those sections, but we have 10 minutes if we can just discuss what we think about this. Hemangi and then Anil. Anil, I don't know if your hand is raised from then or you have a more.
It's okay. I wanted to say that since mediation is a voluntary process,
Voluntary
and
process.
voluntarily both have agreed to do something, so it should be on a different pedestal, just above the agreement. And if court stamp is there, it should be executed like a degree.
Like a degree, yeah. So because it's related to dispute, it's not just any other agreement. We must have a higher sort of status for it. Hemangi?
Same way, madam. If we are agreeing on voluntarily entering into that process and we are giving our consent for settlement, then we can't settle.
Okay. Keshav?
Hello. I think I have little different view, but on the similar line. I believe that it should have the similar level of a degree of a code directly instead of going into the entire process again.
Okay.
Because the person has himself agreed, so he should not be able to challenge it, and the enforcement should be like a degree of a code.
It's okay. So there is a settlement agreement and it automatically becomes like a decree of court, and I should be able to enforce it directly.
Yes.
Why do you say that?
Two reasons, madam. First of all, during a mediation process, this particular the result of a mediation is not a decision given by the mediator. He's just the facilitator. So both the parties have discussed among themselves and came to the common ground to resolve a dispute in a specific manner. So both of them had they had a dispute. They came together. They said, "Okay, we'll agree on this particular terms." Now, once you have already agreed to the terms on your own, there is no reason to go back and again dispute the same, create the same dispute. That's just you are buying the time and you're wasting the time.
So
The
there's
reason
finality to it.
correct, and the reason it should be a decree of a court, unless and until it's a decree of a court, at least in a scenario of India, people won't take it seriously.
Okay.
Yeah.
Okay. Anyone else with another view? Okay. So the thinking is that, look, there was a dispute, they've chosen mediation, they've settled. Often people could make concessions as well. Say, okay, I'm entitled to so much, but I will give that up. Simply because they want to put an end to the dispute. So it's not like any other agreement, and therefore we should give it some sanctity, some respect, right? Make people realize that when you have a settlement agreement, please be serious about it, because like Keshav says, we in India like to get out of things if we can. The other reason is that if we want people to encourage people to use mediation, if they know that if they settle, this is the standing that the settlement agreement will be, then they will be a little more serious about, they will consider mediation more seriously, because they know now, if I enter into a settlement agreement and we settle our issues, then look, this is like a decree of court. So it gives me confidence to go for mediation, right? So that's the other reason. So like I said, different laws have different policies in it. Our Mediation Act says that any settlement agreement, like Keshav said, any settlement agreement that's entered into between the parties will be enforceable as if it were a decree of court, straight up. No supervision by court, no nothing. It is as if it were a decree passed by a court. In Singapore, like I said, it's a two parallel processes. You have to if you have a mediation with someone who is a certified mediator, all parties agreeing, it can be taken to the court will review it and then say, I am approving this. It's like a decree of court. Ireland says, no, it's an agreement, right? So we look at all three laws. Together with that, we will also look at if I am a party to an agreement and I am unhappy with it for certain reasons, can I question that settlement agreement? What do all of you think? Can we allow someone to question a settlement agreement that they have signed after mediation? And if so, when, why, how? Or do we start this topic tomorrow? Please reflect on it. We can discuss this in the morning tomorrow. We can start with this discussion about whether someone who has signed a settlement agreement should be allowed to question that agreement and say, no, I'm not interested in this. I want to challenge this. Right? So we'll discuss this tomorrow and carry on with that. Thank you so much. Good evening to everyone.
Thank you, ma'am.
Thank you, madam.
Thank you, madam.
Thank you very much, ma'am.
Thank you.
Thank you, ma'am.
Thank you.
Thanks.
Thank you, madam.